Order. This is the Select Committee on the Armed Forces Bill. We have three sets of witnesses this afternoon. This is our first panel. Would you like to introduce yourself? We've been using first names at this committee. Is that all right by you?
Certainly.
Thank you very much. If you'd introduce yourself.
My name is Jonathan, and I'm the Acting Service Police Complaints Commissioner.
Thank you very much. We'll get you're very welcome, and thank you for coming to give evidence to us this afternoon. And I'd like to ask Gerald to kick off.
Thanks, Chair. Thanks. Good afternoon and welcome. Could you give us your view on the progress that's been made by the service justice system insofar as the treatment of victims of service offenders?
Certainly. So just to give a bit of context, prior to becoming the Acting Commissioner, I was Director of Service Prosecutions for 5 years, so head of the Service Prosecuting Authority, so I had a good opportunity to see the advances that have been made, and they've been significant. They've been significant. So during the last 6 years, we've seen the introduction of the Victim and Witness Care Unit under the Defence Serious Crime Command. The Service Prosecuting Authority introduced a Prosecution Witness Liaison Unit, which provides support and information at court. We've seen an increase in the orders that have been made for special measures to help victims give their evidence in court. Communications is a key thing. Communications, letters written to victims, has improved significantly, certainly during the 6 years that I've been involved in communications with victims. They've been given a voice, they are listened to more closely, and I think the operations, the lessons that have been learnt through Operation Sitara Bluestone have been put into practice. So, for example, at the SPA, we introduced 2 specific RASO, so rape and serious sexual offences teams, to deal with that sort of work, and we introduced someone with huge experience from the CPS to really quality assure the work we did in that area, in particular with victims. So a huge amount of progress, I think all to the good, obviously, and it came to the point where when the CPS Inspectorate came to take a look at the way the SPA worked, and they produced a report in November of 2024. They actually commented on the way that we dealt with victims and actually said that overall we gave a better service than they had in the civilian justice system. So that was extremely pleasing.
Thanks very much. And obviously you've described a lot the progress there. And is it your feeling that the role of the Commissioner has been sort of significant in all of that?
Well, I'm not sure I could claim that. I mean, plainly, we are there to deal with complaints where they arise. And when our investigators produce reports, they're always looking at whether any lessons can be learnt in respect of dealing with vulnerable persons, so victims, witnesses, in a certain category. So I think we have an opportunity to improve matters, but I think things were doing well before I came into the job. And looking back on the investigation reports, I think that the service justice system was doing a good job before mid-2023 when this office was stood up.
Very much.
Can I just ask about the victims? You say that you've improved the treatment of victims, but I mean, how do you assess the victims' views as to whether the service is improved?
Well, going back to when I was Director of Service Prosecutions, I mean, one of the great things about the introduction of the Victim and Witness Care Unit is that you had a conduit for exchanging views. So if a victim had a complaint or a concern or worry about how they were being treated, the onus wasn't put on the victim to communicate with us. It was done through the VWC. It was done through the liaison officers. So that certainly facilitated communication. Where victims make complaints to us, then plainly we have an opportunity to investigate that complaint to see whether it's made out or not, and to make certain recommendations. But I'm bound to say that in the sort of last 2 years of data that we've only had 7 complaints about police investigations from victims. So broadly speaking, I'm drawing on my experience as being Director of Service Prosecutions to say how that's improved.
So you'd say as a proportion of the complaints that the number of cases, the complaints from victims have reduced?
Yes. So, well, just again, to put it in context, we deal with complaints that are made about service police officers. And I think over the last 2 years, there have been 20 complaints made about investigations. I mean, leaving aside where people make complaints because they say that they've been the victim of an offence or misconduct by a service police officer, dealing with investigations, we've had 20 complaints about how things have been investigated. The majority have been those who were the subject of the investigation, so those whose conduct had been investigated. 7 by what you would broadly describe as victims, using the terminology of the Armed Forces Bill. And they've been to do with not applying the right legal framework, not pursuing reasonable lines of inquiry, and in one case which we've just reviewed, delay. So I think that the Office of the Commissioner has given victims a voice to make complaints where service police officers are said to have fallen below standards. But previously, it's certainly the introduction of both the Prosecution Witness Liaison Unit, but more particularly the VWCU, that's really given victims a voice, because they're proactive in what they do. Everybody who prosecutes wants victims to feel comfortable and engaged with the prosecution process.
Thank you. Paul.
Thanks, Chair. You've sort of answered the questions. Good afternoon, Jonathan, by the way, sorry. So I'm just going to ask a bit of a follow-up, sticking on victims, if I may, because the protocol requires prosecutors to seek assurances that victims have been asked whether they have a preference for service or civilian jurisdiction. And from your experience, though, how meaningful is that consultation in reality, and what safeguards are needed to ensure that a victim's preference genuinely informs decision-making rather than it just being a formality, a procedural formality?
Right, so I am the person to ask about that, because this is all about the protocol. This is all about the concurrent jurisdiction protocol between the SPA and the CPS as to in which jurisdiction is the most appropriate for a case to be prosecuted. And part of that is part of the decision takes account of the views expressed by victims. And so the evidence I have for saying it is meaningful is that I did 2 dip samples during the course of my tenure as Director of Service Prosecutions, and I looked at 60 cases in total, involving cases where you had to have mandatory consultation, so consultation between the CPS and the SPA. And one of the things we looked at was victims' preference. And in the vast majority of cases, they were asked their view. In, I think, all but one of the cases, the chosen jurisdiction coincided with I say preference, and I use that word broadly, so the preference of the victim, or the victim saying that they were content for it to be prosecuted in a certain jurisdiction. And I suppose the most telling point is that certainly in 2 or 3 cases, don't quote me on that, but 2 or 3 cases, where a victim has said, no, I want it prosecuted in the civilian justice system, that has been determinative. So even though the case might have started off in the service justice system, so being investigated by the service police, or having been transferred to the SPA to prosecute, where a victim has said no, and I can think of 2 or 3 cases, I want it prosecuted in one jurisdiction or another, but generally the civilian justice system, the criminal justice system, that has been determinative because of the point I said to the chair earlier. You want victims to be engaged. I mean, no one wants to see a victim miserable because they've expressed a view and it hasn't been followed. I mean, the duty is really to take it into consideration, but I think it's such an important factor, it carries a lot of weight. So what was the second part of the question? Making sure, was it?
Generally, you've answered it really. In what you've said is it actually does the victim's desire, their desire to choose is actually listened to. And do you think that the bill, as it's presented, is robust enough, or do you think that it should be absolutely that 100% the victim's choice?
Well, it's certainly not 100% the victim's choice. It is a factor that there are main principles which generally point in one direction or the other. And the main principle is if there's a civilian interest that's been harmed, if you have a civilian victim or civilian property has been harmed, generally it stays in the civilian. So we're talking about prosecution of service personnel. It generally stays in the civilian jurisdiction. Then you have a whole host of other factors you take into consideration, and one of which is the views expressed by the victim. And I've said for the reason I've given, that is accorded weight. So I know that there's a clause in the bill, because I know the Commissioner is a consultee, whereby the Secretary of State is going to issue guidance about what information should be given to the victim before they express a final view on which jurisdiction they should have. And I think generally that's a good idea, because I think one of the weaknesses of the current system is that you get a tick to say that the victim has been spoken to and asked to express a view, but you don't have full reasoning. So I think it's important that after the victim has made a choice, that they're invited to give their reasons, so you can see that it's informed by factors that matter. So I think the clause in the bill is a good one, but I think that there are difficulties with it, because some of the information you can give victims is relatively straightforward, so the similarities and differences between the two systems. But the sort of information, I'm speaking to an expert, the sort of information you can, that I think a victim would like to know, is about backlogs and waiting times. Now, I think you have to be careful how you couch that, because they vary around the country. And the second thing, which would be hugely contentious, is whether or not you give them information about conviction rates. But I think that would have to be caveated with so many pieces of sort of separate information. I'm not sure that would be an easy thing to achieve.
Chair, could I just have one small follow-up? Thank you. Could you just give the committee just an example, if you could, where the victim's choice wouldn't necessarily be accepted?
Wouldn't?
Yeah.
Yes, I can, because there's one example which sticks out very much in my mind. So this was a case of rape. Female victim making an allegation of rape against a service person. And the victim was asked where she would prefer the case to be dealt with, which jurisdiction, and she said the service justice system. But we learned, if we didn't know before, that the same service person was being tried in the civilian jurisdiction for a rape on a different person. And as a barrister, I can tell you that the case is so much stronger when you try both of these together, because the idea that two or more people are basically singing from the same hymn sheet, it makes it evidentially that much stronger. And so that was an example where, even though the victim expressed a view that they would prefer the case to be dealt with in the service jurisdiction, it wasn't. It wasn't. But it was explained to her, and she understood. And of course, if you explain, well, both of these cases tried together might actually make the case on your rape stronger, then, sorry.
Can I just ask, will the Victims' Code of Practice deliver improvements in this area?
There is, I think I'm right in saying there is already in existence an Armed Forces Code of Practice. I think it was issued in 2015. I know that a new Code of Practice is due to be issued, and I think in both jurisdictions, actually. I think even though they've had a recent Code of Practice issued in the civilian jurisdiction, they're looking at that again. And at the heart of it are the 12 principles. So to the extent that, I suppose, because in my view, there's no point reinventing the wheel. If there's something good which works in the civilian jurisdiction, then generally it works quite well in our jurisdiction. So it transfers across. So to the extent that the 12 principles embedded in the current civilian victims code aren't represented and will bolster the 2015 code, then I think yes. I think yes. I think there's room for it to be improved.
Thanks for clarifying that. Juliet.
Yeah.
Thank you, Chair, and thank you for being with us today. We've talked a little bit about it in the previous question, but under Clause 25 of the bill, how do you think it will improve victims' experience of the service justice system?
Well, the most obvious, I think two things. The most obvious point to make is that it makes victims feel enfranchised, that they're part of the process and their voice is being heard. But I also think that it gives victims more confidence that they're making decisions based on all the information, some of which may not be known to them. So if you can imagine the position where someone is reporting a serious sexual offence shortly after it's alleged to have occurred, and they may have had samples taken from, and all that sort of thing. I think, you'd obviously be worried about a choice made there where someone hadn't had an opportunity to hear all of the factors that they ought to hear about the differences between the two jurisdictions, and may also be not in a state to actually take in the information that they're given. So under Clause 25, and I was involved in discussions about it when it was being talked about within the Service Justice Board, I think what's being envisaged is that at a certain time, when a victim is in a position to take in the information, that they will be given information that otherwise they might not be expected to know. So I'm not completely confident that now, when victims make choices, they're given all the information that they ought to give. So if, as I understand there's going to be a consultation about what guidance should be given them, I think it gives victims far more confidence in the choice that they've made, and they're likely to be, I would have thought, more engaged with the process and the jurisdiction in which the case is being tried.
So could you give us an example of what type of information that they would be given that they weren't given before?
Yes, well, I don't think that at the moment there's any prescriptive guidance as to what information they should be given. I say immediately, I've never been there when a victim has been asked about their preferred jurisdiction and how that conversation goes. So it may be that someone else who has seen or experienced that will be in a better position to tell you. So, so similarities and differences. Examples of similarities is that I was talking earlier about the sort of orders that can be made to help victims give their best evidence. They apply in both courts. Obvious differences, just to give another example. Well, one case, if it goes to court martial, is going to be tried in front of a board. The other is going to be tried in front of a jury. Another similarity, victim care is provided in both jurisdictions. So you're going to get support. You're going to have people explain the process to you. So those are things that they can be told. As I say, the hard stuff is whether you also tell them about, give them information about backlogs, because, I mean, speaking to someone yesterday who has spent a long time supporting victims, I was told that's exactly the sort of information that they would like to have. They want to know, how long is it going to be before my rape trial comes up? Is it going to be 3 years or is it going to be 12 months? And it's very difficult to see an argument against that as long as the information is accurate and it's caveated in any way that people see fit. But then, conviction rates, there's been a huge argument because the civilian justice system and the service justice system measure conviction rates in different ways and express them in different ways. And I think introducing a victim to the nuances of all that, I think, is quite a tough job, and I'm not sure how helpful it is. But there will be people who would argue for it.
Ian.
Thank you, Chair. If I can bring us to the chain of command. So we know that commanding officers have the power to investigate and decide upon minor disciplinary and criminal offences at summary hearings.
Yes.
If I can draw your attention to clause 17, which would require commanding officers to report a serious offence to the service police, regardless of whether the individual is in their immediate chain of command. Do you think this addresses the concerns about the independence of the service justice and complaint system?
I'm not sure whether it's there to address that. I certainly think it's a good idea, and I'd be surprised if anybody argued against clause 17. I think the important thing about it, I'll come back to the second part of your question, if I may, but because I think one feeds into the other. So the important thing about it means that there are certain cases involving Schedule 2 offences, the most serious offences, that are unlikely to fall through the cracks. So you may have, for example, a victim who is serving in a particular area, but she's not serving at an area where her CO, her commanding officer, is in charge. So it might be difficult for the victim to go and speak to the CO, who may be the CO of the person who's alleged to have committed some sort of offence. So that's a good thing. And I mean, if you say that all people who've been in a command position, if they're aware of a service person who on the face of it may have committed a Schedule 2 offence, they ought to report it. Well, you think, it's surprising that you may need the clause, because, as I say, it's difficult to argue against it. So I think the important thing is that it gives a perception that certain cases aren't going to fall through the cracks because I'm not aware of it, but let's say, well, the CO didn't report that for whatever particular reason, because that person wasn't, in his chain of command, or he was seeking to protect him, or whatever it may be. So I think clause 17 is a good clause. I think the duty should be on all commanding officers in the way it's defined in the Act to report Schedule 2 offences, unless, of course, they think that the police are already investigating, which I think is one of the things that allows them not to do so.
If I may, Jonathan, do you have a view on whether this duty is adequate to make sure commanding officers take their responsibilities seriously? But more importantly, what are the consequences if they do not report an offence?
I think the fact that the clause is introduced is going to resonate amongst commanding officers that their duty extends beyond those in their those service persons in their charge. And I think, I don't think there's a sanction actually in the clause itself, but there is a service offence under the Armed Forces Act of failing to perform a duty. So there is an offence. If you fail to perform a duty, I think it's without reasonable excuse or without some sort of excuse, then that itself constitutes a service offence. So if you are a CO and you're aware of that duty and you see a person subject to service law who has, on the face of it, committed an offence, then you're aware that if you don't report that, even if they're not in your chain of command, should it all come out, you stand to be investigated for failing to perform a duty. So, yeah, I think it's an important clause. And
have you, with your experience, have you ever come across that instance where the commanding officers tried to keep it?
I'm aware of cases where that has been the allegation, but when I was Director of Service Prosecutions, I can't think of any clear example at the moment. That's not to say that such a case hasn't come through the Service Prosecuting Authority, but I know that recent cases, which have been dealt with by the Service Prosecuting Authority, which I don't know enough about to speak, there might have been a suggestion that that was at play.
Okay. Alex.
Thank you, Chair. I wanted to ask about Clause 12, which is to do with the Service Policing Protocol, which is to improve the working relationship between the Secretary of State, the Defence Council, Service Police and the Defence Serious Crime Units. In your view, what should be included in this Service Policing Protocol to make it more effective?
So I briefly looked at Clause 12. It wasn't highlighted as one of the matters that this committee might wish to ask me about. But having looked at the terms of Clause 12, it's all about Provost Marshals making sure that I can't remember what the phrase is. I think improper pressure is placed on them when they're conducting an investigation. I think that's the phrase currently in Section 115A of the Armed Forces Act. And I'm not quite sure what has given rise to the suggestion that we have a protocol. So I'm not aware of the cases where it might have been suggested that other Provost Marshals or other bodies have placed pressure on a Provost Marshal, maybe to direct an investigation in a certain way. I realised that I was caught by the duty, because as Director of Service Prosecutions, one of the first things you learn is that you have to distinguish between giving advice to service police as how do they conduct an investigation and seeking not to direct an investigation. I can't tell a service police officer as Director of Service Prosecutions how they conduct their investigation. It's a matter for them. So to the extent that it reinforces, to the extent a protocol is required to reinforce that duty, to make sure that the relationships between Provost Marshal Serious Crime, who sits behind me, the Provost Marshals of the 3 single service police forces, and the other people is that the Defence Council mentioned and the Secretary of State, I think, are also involved, don't effectively exert improper pressure in how to conduct investigation, then it's obviously a good idea. But I was never aware, I'm bound to say, of an example which I thought would require that clause. So,
do you then think it's unnecessary?
Well, I wouldn't say that, because it just might be my ignorance. So I don't want to burden Brigadier Rotchell any more than he needs to be burdened, but because it plainly will affect him and his position, I think he would give you a better and fuller answer on why that protocol may be required and whether or not he thinks it's necessary.
Thank you.
So sorry, but I can't give you a fuller answer.
Thank you.
Yeah, Paul.
Yeah. Just on that, and what's the following from what Alex is discussing, what's your view on the general working professional relationship between service and civilian police? Because if you believe some of the documentaries and some of the programmes that we watch on TV, it's not necessarily the best relationship at times. But is there a professional, strong working relationship between the service police and the civilian forces?
So again, not really my area of expertise. So within the protocol, I know that service and civilian police forces are required to work together quite often within the first 48 hours of something being reported, to talk about jurisdiction, to hand over investigations, that sort of thing. I know that service police forces are used, for example, where you've had a death or serious injury, and I'm not sure I'm using the precise terminology, on MOD land. Then what I always found surprising was that the local constabulary actually have primacy. So if you have an incident in a tank where someone gets hurt on MOD land, under a very old MOU, the local constabulary have primacy. So there are situations where they are used to working together in order to achieve the right result. I'm not aware of any huge friction. In my role as Service Police Complaints Commissioner, I often get reports of incidents, conduct matters we call them, where a service person has, say, got into a fight in Colchester or something, he's been arrested by the civilian police, they may be dealing with it, that there's no fight for the service police to get hold of that. Mm-hmm. So to the limited extent that I've seen how the relationship works in practice, I've never seen anything which has given me cause for concern. But I'm not an expert in service policing.
Thank you. Thank you.
Any other questions? Right, well, that completes our questions on this session. Thank you very much, Jonathan, for coming in and answering our questions and for contributing to our report. Thank you.
Pleasure. If I have a think about something and I realise I can add, can I give written evidence?
Yes, and we've got a few minutes of this session left. If there's anything you want to impart now.
My senior civil servant will no doubt tell me where I've gone wrong. So
right, okay. Yeah, by all means, write to us.
Thank you very much.
Thank you.
Thank you.
Sorry, I'm not going to deal with this now. Okay, welcome. Can I just remind members about the issue of subjudice that we were reminded of previously in this session? Subjudice doesn't apply to this select committee, but we should be cognisant of any current cases that are taking place when we ask any questions. Welcome. We've been using first names, is that all right with you? Excellent, yes. Thank you. If you'd like to introduce yourself, well, we'll get on to the first question.
My name's Alan Large. I'm the Judge Advocate General.
Okay, Rachel.
Thank you, Chair, and thank you, Alan, for being here this afternoon. This bill would give service courts new powers to address sexual harm and domestic abuse. In your view, are these powers appropriate to help tackle sexual harm and domestic abuse in the context of service life?
I think the answer to that is yes. They bring the service system up to date with the civilian system, slightly ahead of it, I think, in one area. But they have to be accompanied by education. So you can't just bring something in and say, there we are, we've done it now. You have to bring it in and tell everyone who needs to know about it. So everyone needs to know that there are, or the people that need to know that there are service domestic abuse prevention. There are service this and that. They need to know about them. Once they're educated at all levels, then I think the system will work better than it is now.
And how do you think we should go about that programme of education?
It's got to be at a variety of levels. The welfare authorities have got to be educating people, service personnel about these orders and notices that you can apply for if you are a victim of domestic abuse, let's say. The police need to know about it. They need to know about what they can do and how to do it. The courts need to know about it. We need to know how to make the orders, how to pass the orders, when not to pass an order. The Service Prosecuting Authority, my predecessor in his past life, and Mary Cowie now in her new life, they need to know, the prosecutors need to know how to deal with them as well. So it's at all levels. It's not just the judiciary, it's not just service people, it's at all levels to make sure everyone understands it.
Thank you. Thank you, Chair.
Just ask, the service courts get new powers. Could you give us a sort of a feel for how that will change from what was previously to what it is now?
I think the first thing to say is that will depend on the number of times that there is an application for such a notice, if that's coming from the police, or such an order. But the court has the ability to impose an order as well. So let's look at that one, which is just the courts. If you have a case with a domestic violence context, you'll be able to make an order that someone must not do, the defendant must not do X or Y. That is an order which is binding on the defendant, for as long as you make the order, whether they're in the service or not in the service. And so that defendant is prohibited from going to such a place or speaking to such a person. That is another way of keeping domestic abuse, let's say, to a minimum by imposing a legal requirement between keeping the defendant away from the victim, let's say.
Right. Okay. Yeah, right. And that wouldn't have happened in the past?
Doesn't happen at the moment.
Okay. Jane?
You quoted statistics in your written evidence saying that the conviction rate last year, 2024, for rape flagged offences in service courts was 29%, compared to 23.1% in civilian courts. Now that's quite interesting because that's actually a bit higher than the civilian courts, but it obviously still low.
It's a case here or there, though,
yeah.
isn't it? Yeah.
Can you talk us through why? I mean, we all know lots of the reasons why, but why the convictions rate is so low for these offences, and why you think there's that discrepancy between civilian and service courts?
I think we have to be really careful with discrepancies. We really do. Yeah. We've got 20 people, 20 cases, and if we have one or two go the other way, and these are done on a 49-51% balance of probabilities, the SPA's test, you can just tip over onto that we're going to prosecute this case, and it goes to the court for prosecution and for a verdict. If it doesn't make it, because it was very, very closely balanced, you then the statistics obviously drop. I think my take on that statistic, and there's another statistic which you may have come across, which is to do with rape flagging. When you add a rape flag to a case, that increases, again, both sets to about 50%, civilian and service. My take on it is that they are about the same, give or take, a little bit here and a little bit there. So I can't say why there's a problem. I think the point is they're about the same. That I think is my answer to that question.
Do you think there's anything in this bill, that will help with that low conviction rate?
Not that immediately comes to mind.
Do you think it is a low conviction rate?
That's a bit, if I may say so, that's a good question as well, because I think 50% of cases isn't bad, really. 30% of cases, that's 2 out of 3 not guilty, 1 out of 3 guilty. One would like it to be more than that, perhaps, but it is the conviction rate. The conviction rate is the conviction rate, isn't it? So you whichever rate you take, you are. This bill deals with things around the edge of the cases, not the central issues. There are other cases other bills being discussed in this House this afternoon, which may have a different effect on the conviction rate, but I don't think this is necessarily going to affect it.
The last part of the question is: do you have any thoughts on the decision not to take forward the Lyons Review recommendation, so not to make these serious offences solely civilian jurisdiction?
I've got a number of thoughts. The Lyons Review reported in 2018, so a number of years ago then. Since then, and the government at the day did not follow the Lyons proposals. What they did instead, and this government is doing the same thing, is making big steps to modernise, improve the system. So we have a defence serious crime unit, we have a victim and witness care unit. We had another study by a gentleman called Henriquez, Richard Henriquez, a High Court judge. He didn't want to do away with murder, manslaughter and rape. They were arguments. His argument was quite well made, I thought. We've introduced mixed board members. There's a lot of different things that have happened to make the journey of the victim through a case better supported. Jonathan was talking about extra special measures, Jonathan Rees, my predecessor, things like that. So there's a lot has happened since 2018. We are not in the same place we were in. We still have that jurisdiction. If you want me to talk about that jurisdiction and why I think we should retain it, I can do so, but I don't think that was necessarily your question.
No, thank you very much.
What's a mixed board member?
Mixed board. So we now have on a rape board, will be 6 board members. There'll be 2 from the Navy, 2 from the Army and 2 from the Air Force. So the 6 Army officers trying an Army officer for rape have gone. It's now mixed boards.
Right. Are they gender balanced or anything?
The gender balance, there has to be one person of each gender on the board. Now, obviously, noting the gender mix, that is usually to make sure there is a female on the board. In fact, I went into a room to do a sentencing case not so long ago. There were 3 females ready to do the sentencing. And I said to them, I'm very sorry, but we have to get a male. We have to get the waiting member to replace one of the females, because we had 3 females. So it does work both ways.
Okay. Thank you. Paul?
Thanks, Chair. You'll have heard this when we were speaking to your predecessor, Jonathan, just before around jurisdiction again. And so we can take you back to clause 25, which would require the Secretary of State to introduce guidance on the exercise of criminal jurisdiction, as you're aware. In your personal view, what value would this guidance add, given that the protocols already exist between the service and civilian systems?
I've heard Jonathan's answers, and I could say I just agree with them and leave it at that. I'll try to put a little more flesh on the bones.
He's left the room, so it's fine.
I think it is going to be difficult for the Secretary of State to give too much information. He will be able to talk about the similarities and the differences. We have 6 jurors, 6 board members. You have 12 board members. We have 3, 2 from each service, 12 from the jury, that sort of thing. The law is all the same in a rape case tried in the court martial or the Crown Court. It's exactly the same law. So that can be explained. When it gets to things like conviction rates, when it gets to things like delay, the Secretary of State and his team will have to work out how to deal with those issues. It may be that they can be done with a chunk of the country where the delay is a year, that is explained, and the other chunk where it's 3 years, that's explained. I don't know what they'll do. It's useful to have. It will be helpful, but it will need careful work.
Do you accept the argument that there's been quite a number of some controversial cases over the past few years where it's deemed that the service system hasn't necessarily acted in the best interests of the victim, and therefore giving choice outside of the service for serious offences is fair and more fair for the victim to take it outside of the service system?
If I answer the last half of the question and leave the first bit, it is certainly very important that we take the victim's wishes into account when deciding on the appropriate venue for trial. So if the victim very much wants it in the civilian jurisdiction, it will go there unless there's a really good reason for it not to go there, seems to be. And if the victim very much wants it in the service system, it'll go there unless there's a good reason for it not to go there. I think that's probably an answer to your question.
Yeah, and I'll withdraw the first part of the question as well. Yeah, I understand that. I apologise.
No problem.
Yeah.
I just thought that's actually different, and we're obviously debating this today here. That's different to what would happen in a civil court, because the victim wouldn't have any say at all, would they, over where or how the case was heard in the civil courts? But they do. They would under this system. That's quite interesting. Thank you.
They do have already. I mean, they are spoken to.
Yes.
Jonathan makes the point, I make it as well. The quality of the data isn't perhaps as good as it might be, and they may be very upset at the time they're being asked the question at the moment. But if that can be regulated a bit more to make sure that they understand when they want to know, sometimes they will be very clear on what they want to do. But if they want to know the information, they get information upon which they can base their decision. That will be helpful.
And that's the difference.
Okay. So the next question is from me. Do you have any other views on the bill's provisions on service courts? And are there any areas that you feel the bill doesn't address?
There's one I want to point out. It's been pointed out to the officials working on the bill. And this is to do with people who have left the service by the time they are brought to trial. So we can try people who are serving, we can try people who are not serving, and we do try people who are not serving and they've left the service. At the moment, the drafting of the Act, of the bill, does not allow the service courts to impose the new orders. There are service restraining orders, the service domestic abuse prevention orders, etc., on the people who have left the service at the time of trial. So we need some new words to bring them back into the fold. I suggest it's a matter for policy, not for me, but as a lawyer dealing with the system, the current drafting, and I apologise, I didn't spot this. Mary Cowie spotted it. She pointed it out to me, but I'm just flagging it up now. There is a problem, I suggest, in dealing with the service person who's left the service when he's being tried by the services. He's left the service, but he's on trial. We cannot impose those orders. We can enforce them if they are imposed when they're in the service, but we can't impose them once they've left the service. That's something that needs tightening up, I suggest.
Okay, thank you. And can I just take you back to the conviction rates? There is a general low conviction rate in this service justice system. Is there an issue there that needs to be addressed?
I think you said to me, is there a low conviction rate? Is there a low conviction rate compared with civilian systems? When you take off all the flags and tags and everything else, I don't know.
Should you?
Possibly, but I don't know whether the overall conviction rate is lower than the civilian system. There will be, as there are in this case, statistics on one side, from 70%, some people say, down to 29%. I think was that you've got conviction rates from 70% down to 29% on the same offence in rape. So where's the true statistic? It's very difficult to find a true statistic. Do I think there is anything that needs to be done to improve the conviction rate, whatever it's at? I cannot think of anything while I'm speaking to you that would make me that I think needs to be done. I think we have a system which reflects the civilian system, except for board members and things like that. So the system seems to me to work.
Well, is there anything else? Because we've actually flown through our questions for this session very quickly. Your questions have been very concise. Your answers have been very concise. Is there anything that we haven't probed that you think we ought to be aware of that you'd like to add?
Let me just have a quick look. I think you've covered all the ground I was expecting you to cover.
And if there's anything on the conviction rates that springs to mind when you go away and have a look at the figures, then please, by all means, write to us.
Thank you very much.
Thank you, Alan, for your evidence this afternoon. Thank you for helping us with our inquiry.
Thank you.
Order. This is the third panel this afternoon of the evidence sessions on Select Committee on the Armed Forces Bill. You're very welcome. If I ask you, we've been using first names, is that okay? Thank you very much. I really appreciate that. And if you introduce yourselves, we'll get straight on to the questions.
Thank you. So I'm Nina Slocombe. I'm the head of Defence Victim Witness Care Unit, and we're responsible for providing victim support to the victims and witnesses going through the service justice system.
Thank you, Chair. Chris Rotchell. I run the Defence Serious Crime Command within the Ministry of Defence.
Excellent. And Mike is going to ask the first questions.
Thanks, Chair, and thanks for coming. So we're going to start out with you guys marking your own homework. So since we've established the Victim Witness Care Unit and the Defence Serious Crime Command, how would you say, what's been the progress of the service justice system in the treatment of victims? And Nina, would you like to go first?
Absolutely. So when we stood up in March 23, with DSCC standing up in December 22, when we opened our doors, we initially had the rush of ongoing investigations. Since then, we've looked at the narrative and hearing the victim's voice. That absolutely has to be key in everything we do, in ensuring that the victim's voices are heard, recorded and escalated when things have gone wrong.
Was that not the case before?
I would like to think it was. There was also victim liaison officers available before we stood up, before a dedicated professional victim liaison unit was around. The service police would provide that. Also, there was independent victim advocacy service also available. But with the victim witness care unit standing up, it's a central point for the service justice system, not just for the victims and witnesses, but also to ensure the flow of communication and passage of information between the professional stakeholders.
Thanks. And I think from a policing perspective, there's a couple of really key points to get across about those changes and those advancements. I think first and foremost, structural independence is really crucial. Prior to the formation of Defence Serious Crime Command, the responsibility for serious criminal investigations within the service justice system sat inside each of the single services. That's now changed. My position, my command is completely independent from the three single services. We don't report to them, we don't answer to them, and therefore we investigate completely independently of them. I think the second thing I'd highlight is that continued demonstrable professionalisation of service policing within defence. I think our direction of travel is clear. In that we want to ensure that we abide by national UK best policing practice, both in terms of the way we investigate, operating inside the College of Police and National Police Chiefs Council guidance, but also in the way that we train, develop and accredit our people to professional standards. We utilise the College of Policing's Professionalising Investigations in Policing programme as the benchmark for that. I think that's really important. I think we continue to work on getting the right governance mechanisms right. It's absolutely right that we're held to account. And you've already heard from Jonathan Rees, KC, the Service Police Complaints Commissioner. For me, as a Provost Marshal, as a Chief Officer within Defence, that's hugely welcomed. Our people, our decisions, our processes, the way we interact with both victims and suspects and witnesses and our community must have an avenue for us to be held accountable. And then I think really importantly is external scrutiny. We are currently engaged with and communicating with His Majesty's Inspectorate of Constabulary's Fire and Rescue Services about their first statutory inspection of us. And I think that external scrutiny is absolutely vital for us to be able to demonstrate that we are independent, that we do place victims at the heart of what we do, and that we work really hard from both a victim and an investigative point of view to secure the right outcomes for victims, which is really our headline, securing the right outcomes for victims.
I'm paraphrasing slightly, but I was quite struck by you saying that your governance mechanisms are evolving. Did you say that? Where are they going from and to? What's the journey that you're on?
So the journey really started with the creation of Defence Serious Crime Command. The reason I say they're evolving and we're on a journey is Defence is currently undertaking a governance review of all service policing, so not just my organisation, but the other three service police forces, to ensure that the correct governance is placed above us.
And then I was also struck by you championing the independence of your organisation, which is great. With Operation Northmoor, which was the investigation into the Afghan Special Forces allegations, some would argue that was shut down prematurely. Would you say that could not happen now with these new governance arrangements and independence that you have?
So I'm aware of the Afghanistan inquiry, and for complete transparency, I have been an open witness to it and given a corporate view on that in terms of what happened in the past. So I'm aware of what the position was then. I've also listened to much of the open evidence in the inquiry as to expert views on it. My view is that absolutely couldn't happen now. I have a statutory duty. It's placed on me personally under Section 115A of the Armed Forces Act to ensure that any investigation undertaken by Defence Serious Crime Command is free from any form of improper interference. I take that duty extremely seriously. By any improper interference, I consider that to include anybody, and I include from the Secretary of State right down to any member of the forces. And I'm confident because of that our investigators are able to pursue any line of inquiry that they feel they need to, and they should be trusted to get to the truth of a matter. I think really importantly, if I link that to the Armed Forces Bill, Clause 12 of the Armed Forces Bill, I think strengthens that even more. At the minute, that duty is just on me. It's my duty, or our other Provost Marshals in Defence, to make sure that happens. That clause places a duty on everybody to ensure that they don't do anything that would interfere with a police investigative process or an operational policing decision. And I think that clause gives us real clear equivalence to Home Office policing, and it mirrors some of the provisions in the Police Reform Act, and ultimately sets out that governance best practice that the public in our community would expect, because nobody would want to think that any police force could come under any form of political or any form of pressure to either investigate something it shouldn't, to cease an investigation, or to take an investigation in a different direction.
Thank you. That's very clear. Thank you very much. Nina, both of you have actually given a really good picture of progress that's been made, and Kristian just finished up there with something that he thinks under Clause 12 is going to be further improved with the bill. Is there anything else that the bill is going to bring in that is going to improve that picture and drive further progress, either for victims or for the other side of the argument?
Absolutely. There's several measures in there from a victim witness care unit perspective that we are highly pleased about. For example, Clause 5, Clause 6, so the sexual harm prevention orders, the sexual risk orders. I can't stress enough how this is going to provide to victims and witnesses who we refer to as clients, to provide our clients with enhanced safeguarding, mitigated against risk, and that will allow to place additional, I think Jag spoke about it earlier, about placing additional prohibitions and restrictions on these offenders. Also, the sexual risk orders, a conviction's not required for these, so this can be placed on an individual whilst an investigation or the judicial system is ongoing, and that will provide an enhanced safeguarding and fill a safeguarding gap for our clients. But I think one of the strongest clauses is in 6, which is the prevention of domestic abuse and stalking. Stalking as an offence type is not to be underestimated. It may be lower in percentage on our stats, but the harm is very much there and real. And we feel that this clause will address the most significant safeguarding issue amongst defence and VOG in defence. It will mirror the Domestic Abuse Act 21 and the Stalking Act of 19, allowing early intervention, reduction, reducing risk, and victim safeguarding. So those are the 3 main ones that we welcome for not just the safeguarding, but it may also assist a client in engaging, to continue to engage. We've spoken about victim attrition already today, and I'd like to think these will go some way to reduce the victim attrition, to keep them engaged in the system.
Kristian, is there anything you want to add?
I think I'd really like to highlight, I mean, I think there's lots of measures in this bill that are really important. I think this bill is a huge opportunity for the service justice system to perhaps close some gaps and make sure that we keep pace with the criminal justice system. From my perspective, that is about placing victims at the heart of what we do. Our primary role as a policing organisation is to protect people from harm. Closing those gaps, ensuring we keep pace, ensuring that we can deliver the right service to our community, and particularly those individuals who are part of it. I think if there's 2 that I could really highlight that I think are really significant and really necessary from perhaps my perspective as, I suppose, Defence's most senior police officer, is Clause 17, which is the expansion of the duty of a commanding officer, and Clause 15, the pre-charge custody. Both of those significant and necessary. If I take custody first, clause 15, I think probably all of us would agree that it's slightly unusual that an employer of an individual would be the person who had a say in the middle of a police investigation as to whether someone should take that really serious and significant step to deprive someone of their liberty without knowing the full facts of an investigation and understanding the implications doing so or not doing so could have on that investigation. This places that power rightly with the police, where the police think it's necessary, and I think really reinforces the independence of investigations. I think perhaps if I then turn to the expansion of a CO's duty, which expands that statutory duty to ensure, ultimately from a policing perspective, that more allegations make their way to the police. Previously, I think it was a great step, and I think that duty doesn't exist, I don't think, anywhere else within the UK justice landscape. So it was always welcome, but this it was perhaps too closely aligned to the specific chain of command that a commanding officer was in and an individual was in. And as a commanding officer, myself, I'm very clear that this new duty places more focus on the need for police investigations where something serious, a serious crime, may have happened. And I expect there's probably different views on whether this goes far enough and whether that provision should be expanded further. My view from a policing perspective is it does go far enough. We've certainly considered internally to the police and in line with our victim colleagues whether it goes further enough. What we're concerned about with it going further is the real chilling effect that could have on our service personnel, particularly our victims who may wish to speak to someone, may wish to communicate with someone as a friend about something that's happened to them. And criminalising that, I think, would have a real impact on the agency that victims have in their journey. So I think it ensures the chain of command does the right thing. It places a statutory duty on them. I listened to previous evidence about what happens if someone fails to do that, and I think I don't wish to go into any specific cases. I think that would be challenging for us, but I can say that there are a number of investigations and sub judice matters that relate directly to commanding officers failing to fulfil that duty, which shows positively that we do take action, we do hold people to account when and if those circumstances do arrive. So it's about placing chains of command in a position to do the right thing but retaining agency for victims.
Thank you very much.
Right, I've got, it's okay, Mike, I can chair the meeting. I've got David, I've got Rachel, and then I've got Paul. Rachel, do you want to come in on this?
Yeah, well, it sort of deals with some of my questions.
Okay, I'll come to you when it's your questions.
I'll
take David, then Paul.
Thank you, Chair. Brigadier Nina, thank you very much for being with us today. There are a number of different mechanisms and structures being brought into defence, and individually many of them have merits, but for me it's the problem between problems. So when we look at the new sort of structure around the Armed Forces Commissioner and the new powers that Commissioner will have to be able to go into bases if there's been a crime reported, and to be able to request information from CEOs of that military organisation, how does that work in conjunction with your organisation? Do they have to seek warrantry from you and you have to go to the court? How does that work in practice?
So I'm not sure I can fully answer that question. I'm very clear on our ability to enter locations and to seek certain things using statutory powers that exist to us. I think it's perhaps something that Defence may be able to come back to you and answer that more broadly, because that overlay between powers of the Armed Forces Commissioner and Service Policing isn't necessarily something that I have complete clarity on right here, right now. So I absolutely wouldn't want to mislead the committee.
Is that a conversation that's been forecasted for the coming months and years as the Armed Forces Commissioner position is established?
I think it's something that absolutely needs to be discussed, but from my perspective, that statutory and operational independence of policing and our ability to conduct our investigation is set out in legislation and absolutely tantamount. Thank you.
Oh. Yeah, thanks, Chair. Just going back, Chris, something that you mentioned about that you offer the professional standards function for the three service police forces, for want of a better word. Now, there has historically, unfortunately, in all the services, police investigations, been some controversial cases over the last few years. Without going into any particular detail, but can you confirm that you have undertaken significant investigations into the individual forces under the professional standards umbrella, and how is it dealt with? You know, within if you believe and understand that an investigation or an individual officer within, I struggle with terminology here because it's police officers and they're not called police officers within the services. I do apologise, but you understand where I'm going. If you don't think an officer's there's professional standards, as in civilian, that it has to be dealt with, how is that then dealt with? And have there been investigations, and have there been, for want of a better word, sanctions against those individuals?
Yeah, and I certainly wouldn't go into any specific cases. Yeah. I think, to clarify, each of the 4 service police forces has its own professional standards department. Within the Defence Serious Crime Command, we have a professional standards department, and we also have the remit to investigate what are Schedule 2 offences under the Armed Forces Act. So I'll speak for the Defence Serious Crime Command. There absolutely are instances where either our allegations have been made against service police officers and they've been investigated and sanctions have been applied. I think really importantly is the role of the Service Police Complaints Commissioner, because that sets out on a statutory basis the requirements for us to inform and report certain specified matters that could account to misconduct or gross misconduct to currently Jonathan Rees's team, for them to independently investigate that. And again, I'm very happy to confirm that there have been a number of instances where we have referred matters and ourselves to the Service Police Complaints Commissioner, much in the same way you would expect to see a Home Office police force refer itself to the Independent Office of Police Conduct.
Okay, Rachel.
Thank you, Chair, and thank you for attending this afternoon, and thank you, both of you, for your service. You've already touched on Clause 17 and the statutory duty. So, Kristian, do you think that duty is enough for commanding officers to take their responsibility seriously? And what are the consequences if they choose to ignore it?
So I do, and I think I explained, or I hope I explained, that I think it going further is right in terms of Clause 17, but I'm not sure we want to go further because of the chilling effect I think it could have on victims. In terms of consequences, sorry, could you just repeat the section on consequences?
Yeah, I mean, it's really asking you what are the consequences if a commanding officer chooses to ignore their statutory duty to report things.
So, as a Service Police Force, Defence Serious Crime Command, responsible for those type of investigations, we take them really seriously. Section 113 of the Armed Forces Act is what currently places that duty on a commanding officer, and obviously this will expand that. It's really fundamental to operational effectiveness in defence, because it's that glue that holds us all together. We need trust, and that's where we're going near a breach of trust. So the consequences can be severe. They can range from a criminal investigation for misconduct in public office, which, as you know, is a very serious criminal offence, right through to, and I think it was either His Honour Judge Large or Jonathan Rees mentioned service-specific offences such as failure to perform a duty, negligently performing a duty, conduct prejudicial to good order and discipline. So there's a range of outcomes, and there's also employment action that the individual single services could take. I think I don't want to over-egg the reporting by a commanding officer, because there are a number of methods and mechanisms for reporting serious criminal allegations in defence. That can be directly to us, that can be and is sometimes through the chain of command. And quite often the chain of command can be a huge benefit to individuals, particularly where that chain of command's functioning very well and is trusted by those individuals. I think one of the most important things that we've still got to do, and we are doing it right now, is bringing in a really clear, coherent mechanism for victims of crime in defence to be able to report directly away from their chain of command. And we're bringing in currently an IS programme called Single Online Home, which will give that ability for anybody, anywhere in the world, at any time, as long as they've got access to the internet, to be able to report a crime online to us that will go nowhere near their chain of command, much as you would see if you went onto any one of your constituent Home Office Police Force websites.
Yeah, and sort of dealing with that aspect, Nina, if I may, the service justice system is frequently criticised, I think, for its lack of independence from the chain of command. And how often do you encounter cases where a victim believes that the chain of command has reacted inappropriately in their case?
So upon conducting risk assessments and initial narrative with the clients, and through the course of their journey with us and through the SJS, sometimes it has been disclosed, and the areas sometimes they've reported stuff and it hasn't been promptly dealt with, but it has finally been dealt with, or they have felt just not supported within their day-to-day work. you've got to look at the co-location, which is one of the biggest fears for people coming forward. And when they're with us, they could be serving on the same warship, deployed, a small detached unit, or even simply living in the same single living accommodation. And that is very much a live fear. But going back to the chain of command, we ask our clients, do you want your chain of command informed of this? As in, of the service they're being provided by us, and indeed the investigation. And the majority are okay with their chain of command being informed, but there are definitely cases where it's their choice to not have their chain of command informed, and that is something we will absolutely honour, and we won't share or discuss any information with the chains of command. What the victim liaison officers are able to do, because they're independent from chains of command within the single services, is be the advocate, if required, for the client, and to make sure that any grievances are escalated and dealt with in a swiftly manner.
Do you think it's a common problem, though, that victims or clients are encountering cases where the chain of command have reacted inappropriately, or is that rare? How?
From a client's viewpoint, from my side of the fence, if you will, it's more common that chains of command are being supportive in the workplace or deployed. It's a smaller amount that have not been.
Okay, is there anything you want to add to that,
Kristian? I think from my perspective, in broad terms, I would completely mirror what Nina says. I don't have right here, right now, the data on the number of those offences that we've undertaken since our inception, but we would be very happy to provide those to you either tomorrow, I think you're visiting us, or in writing, if that is something that you would like, Chair.
Thank you.
If you had anything to add, yes, that would be helpful.
Okay.
Luke.
Thank you, Chair. The new service policing protocol is supposed to ensure the independence of investigations and improve working relationships between the various service policing bodies. Can you give us some insight into the need for the protocol and the current state of the working relationships between the DSCC and other service police forces?
Yeah, of course. Now, I may have covered some of this already, but I think it's really important to reiterate. I think the headline point for me is about victim confidence and victims having confidence in the independence, and particularly the operational police and independence of investigations. And I think this measure is really pivotal to increasing victim confidence. I think structurally, that structural independence is really important. And I'll come back to that in a moment, because it links to how we interact with the other service police forces. It's really adding to that duty you placed on me and my colleagues in the Royal Military Police, Royal Air Force Police and Royal Navy Police, to ensuring everybody in defence understands what their role is. And I think that can only be a good thing. And I think certainly if I look at those sort of headline policing principles of effectiveness, efficiency and legitimacy, really, really chimes with legitimacy. In terms of how we operate alongside other service police forces, well, we all operate within the same service justice system. There are clear delineators in terms of responsibility. The 3 single service police forces have a responsibility that largely aligns with Schedule 1 of the Armed Forces Act, those less serious offences, whereas our focus is on Schedule 2. We as an organisation are entirely dependent on resourcing from those 3 forces, with the exception of some civil servants and some external civil policing contractors, civil policing contractors that work within our organisation. We're entirely dependent on them for resourcing. We are also currently dependent on them for the provision of some aspects of first response policing, very much like a neighbourhood policing team would operate in a Home Office force, and also for the provision of many of our specialist capabilities, so digital services, forensics, both wet and dry forensics, and some other aspects. I think, but we don't just operate with our service police colleagues. I think the question was asked earlier about Home Office police forces and how we interact, and I don't know whether that it would be useful for me to expand on that, or maybe wait and see if that's something that Chair wants to ask.
If you feel it's relevant, then I would be happy.
I think it's relevant because
we do have time.
Thank you, Chair. Because I think policing is an interagency business, isn't it? And police reform will look at many of those aspects, and defence is also going through its own version of police reform, both in terms of governance and structures. But in terms of how we work with our Home Office police and other national police and agency counterparts, I think that's really important because we work collaboratively with all police forces where our paths cross or where our requirements cross, whether they're inside or outside of defence. And ultimately, and I said earlier, we're working to the same professional standards, both in terms of our policy, our doctrine, and our professional accreditation. And we... I mean, as of this week, we have got one of our investigators embedded in another police force's investigation into the sad death of a service person recently, both to support them and give them that service knowledge where they require it, but also to ensure that we are working together. We sometimes use their custody facilities, for instance, where that is the best thing in terms of safeguarding the individual we're dealing with. And we also rely heavily on each other for external reviews at times. Certain cases, certain decisions, sometimes it's very sensible to have a peer review. It's even more sensible to go outside your organisation to do that. So we work as collaboratively as we're able to.
Okay, Rachel. Oh, no, it's Paul. Sorry, beg your pardon.
Thanks, Chair.
Beg your pardon, it's my writing.
If I may, Nina, back to the victims. Something we're all passionate about, and we started talking earlier about, and discussing your views on the new powers to use restrictive orders to protect victims of sexual harm and domestic abuse, for example, and you've mentioned stalking as well. Have you any concerns about them, and do they go far enough?
I would say the measures proposed will go far enough. My concern will be how they're implemented. It needs to be timely, it needs to be robust, there needs to be adequate training for the individuals undertaking this, and that will be all professional stakeholders who will have interaction with these orders. And like everywhere, it will need the requisite workforce. This is not something you can pay lip service to. It will need investment in. So that's my concern, how that's going to move forward.
Yeah, because if these orders, so you mentioned stalking before, didn't you, as an example, but it's clear all the services have to now start maybe perhaps doing things differently, because if these orders are in place, these people need separating, they need different accommodation if they're married, for example, if there's children involved, and there's quite a lot of work to do here. Would you agree with that?
There is, but what I will say is there is already mechanisms in place in each three single services. They just differ slightly. Why do it all the same? So when you need to mark somebody's employment card, if you will, in layman's speak, so to make sure that this person A cannot serve or live with service person B, and each three single services do that slightly differently because of different systems, but it is being done. What these measures are going to do are make them legally enforceable with consequences if they're not adhered to. So my concern or my question is, how quickly are these going to be implemented across the service police as a whole, because it will definitely, I think I'm right in saying, affect all three single services, and probably those first responders maybe, so which would not ordinarily be DSCC, but everybody will have a responsibility.
And it's on just Chris. So this is obviously there's on the military side of things here. There's clearly impacts here, because I, as a veteran, I'm struggling to understand. when we had the Queen's regulations, as it was, there's high standards expected of you. And if you've got an individual who's suddenly subject to a stalking, domestic abuse warrant against them, for want of a better word, how has it been considered how that's going to affect operational effectiveness? Because and is that individual then going to be extracted, from not just from one element where there's clearly evidence there. I know nobody's guilty until they're found guilty, but I do wonder as what the military have considered the impact of these orders is going to have on the operational effectiveness of the service.
So, and you'll know as a veteran that the defence context is in many ways unique, isn't it? And I think quite rightly so, because of what we ask our service personnel to do, and where we ask them to do that. But I think where it can't be different is where we're talking about the basic standards of protection for victims. So, and I think our experience is clear and probably chimes with that victims in service don't want to, nor should they have to necessarily face someone that's harmed them on a daily basis. But what our service personnel, certainly in my experience, all want to do is come to work to be able to do the job that they're proud to do without fear of any repercussions, of any harm, and they do an amazing job. So, I think we're likely to see, as you've said, sort of conditions that are based or focused on geographic and contact for both victims and potentially witnesses as well, in some cases, and obviously suspects. And we want to prevent further harm to them. We want to prevent further offending. Training and education is going to be absolutely crucial to this in terms of its application across defence. And I think it will require various chains of command to make really clear, bold employment decisions to uphold these orders. I say orders because that's really important, because these are going to be judicial orders. And the chain of command will have to abide by them, and that's why it's a significant step change. I think from our perspective, internally as a policing organisation, we've got to make sure our training and education is right so that we can be part of that journey. We've got to get our resourcing right in terms of how we apply these measures in conjunction with our excellent victim specialists and our colleagues in the prosecuting authority and the judiciary, because we shouldn't be asking Parliament for legislation that we can't bring in practically. So getting our resourcing right and our skills and experience in those areas from a policing perspective, alongside the chain of command being clear on what their roles and responsibilities are crucial to the success of this.
So with that, obviously, given the very unique nature, the global nature of what the forces undertake, clearly these orders, would you agree these orders and the chain of command must understand that these orders must never be at the detriment of the victim?
I absolutely would agree.
Never be, and that's a challenge that we have. And finally, for me, are these orders, these are military orders, this is, if they're dealt with through the service system, are they shared with the civilian police agencies as well?
Certain aspects of them are. I think Judge Allen highlighted an area where there might be some further work required to make sure that the best possible protection is provided by ensuring they apply equally whether someone is serving or not. What I wouldn't want to do is mislead you in terms of what those specifics are, because I think they're quite detailed legislative points.
Okay. Thank you both very much. Thank you, Chair.
Nina, I'll come to you. Do you have any views on the extension of the multi-agency public protection arrangements under Clause 9?
MAPA, yes. Again, this is a welcomed clause for us, particularly when it comes to the offenders leaving service, whether they are they leave of their own fruition or they are dismissed. And at the moment, as it currently stands, when they are sentenced to a HMP as opposed to a MCTC, which is the Military Correction Training Centre, if they're sentenced to a HMP, it's automatic dismissal from the armed forces. What my department will offer is then the victim contact scheme, and that is they will opt into that if they wish, and we will link them up with the relevant probation service to make sure that they are kept informed and given the option to provide a victim personal statement if a parole board comes up or discussion around early release, and they will be given updates on the offender. The same happens if they go to a military correction training centre. But what the MAPA process is going to do is enhance that safeguarding and provide, I hope, extra confidence and safety for the clients, whether the individual is still serving and that risk is managed, or if they are outside in civilian streets. So the MAPA clause is, it's multi-agency. It is what it says on the tin. It's police service, probation service, social workers, possibly ourselves, attending that multi-agency approach in reducing the risk. So, we welcome the MAPA Clause 9.
Do you have any to add, Kristian?
I think for me, from a policing perspective, again, we welcome anything that safeguards people. I think particular to Clause 9, it's really important for that small number of people who may meet those MAPA criteria and for whatever reason continue to serve in defence, particularly where they're required to go overseas or to step outside of the UK jurisdiction, ensuring that public protection is applied not just in our community, in the UK as a whole, but internationally, which I think is really, really important.
Okay, good. Nina, the bill would introduce a new Victims Code of Practice. Can you tell us more about what you think the code will achieve?
For us, currently, as somebody else has already alluded to today, the Victim Code of Practice is written in policy in a joint service publication, 839. So to see this legislated is an absolute welcome. What I feel is it will cement the 12 victims' rights that every victim and witness is entitled to and should be offered and delivered, regardless of the justice system which they follow. So to have that enshrined in legislation is absolutely key, and also it will allow individuals who got a responsibility to victims of crime, because this is so much wider than the service justice system. This is, as we've already spoken about today, the commanding officers, the second in command, the sergeant, the leading hand in charge of the mess. Everybody does have a responsibility. So if that responsibility is not followed up on or executed correctly, that's quite a technical phrase, so I apologise, we've got something to hold them to account on. Because no victim should not be given their victims' rights and the support within the armed forces. So we welcome the codes being cemented.
Grateful. Kristian, do you have anything to add?
Victims have got a bit at the heart of what we do, and I think that's crucial.
Excellent. So how will introducing a new guidance on criminal jurisdiction under Clause 25 of the bill improve victims' experiences of the service justice system?
Yeah. So I think ultimately this is about giving victims more voice. I agree with the comments of previous witnesses that highlighting the differences, highlighting the similarities, and really allowing victims to give an informed preference from my perspective can only be a good thing.
So already our victim liaison officers, if we're contacted before an individual has actually made a formal police report of a serious offence, they will ask on occasions, what's my options? And the victim liaison officers will lay it out in a way that is balanced. It won't be highlighting the strengths and weaknesses of each justice system. They will lay the facts out of the criminal justice system and their pathway, and the service justice system and the victim pathway, to then help that individual make an informed choice moving forward. But it's key, they need to be informed of each.
So when they make that preference, are they respected or are they encouraged to? Do you think it's taken into consideration enough?
Absolutely, that's already been said this afternoon, that preference is taken into account. And from what I've seen and read from the Victim Witness Care Unit perspective, is more often than not, they are content with the service justice system that they're going through. And even if maybe they weren't to begin with, they've started to understand actually this is a benefit for them to go through, because we have had victims go through the civilian justice system who are service personnel, and they've had to repeatedly explain what their role is, what a deployment is, and all the technicalities that come with the complexities of a service life, whereas all the professionals within the service justice system understand the service life and the complexities.
So just so clear, so when victims express a preference, that preference is respected, people take that into consideration. Okay. And we had questions earlier on about conviction rates. If I come to you, Kristian, do you think the conviction rates in the service, the defence service justice system, are high enough, or are they about right, or hard to say?
I think it's hard to say. I think there's so many different metrics that can get used, and I think as Judge Allen highlighted, in comparison to the more than 60,000 cases reported in the criminal justice system annually, the number of the most serious sexual offences particularly, it's significantly lower, so there can be anomalies. We always want, from a policing perspective, I want to see high quality, timely investigations with outstanding victim support associated with that gives the best prospect of a victim securing justice. So for me, I would be very wary as a policing professional to talk about wanting to see conviction rates, because my part in that journey is about high quality evidence, allowing prosecutors and courts to make decisions. But what I would say is we always want to see the right outcomes for victims. So I think we've got to work holistically to make sure that every piece of that justice chain delivers the right outcome. And perhaps not answered your question, Chair, but I think from a policing perspective, it's hard for me to gauge whether judicial outcomes are correct.
What do your victims say to you about the conviction rates?
So, when our clients have gone through trial and the sentencing has been passed or not, with an acquittal or not guilty, of course they're going to be upset and distraught. But we've also had clients who haven't had a positive outcome at court. By that I mean a not guilty finding, but what they have said is, but I have felt supported all the way through, and I've understood, and I've had the support I've needed to get through the trial. Because as in any justice system, if you don't get the process right and the support right going through investigative, prosecution and trial, it can be classed as a second trauma to the client. And in some cases, it can actually be more traumatic than the initial incident that they reported. So I can't sit here and say those clients that hadn't got a positive outcome were happy about that. Of course they weren't. But I think what we need to do is ensure that these measures, they are implemented in a timely and correct manner, whilst still providing the victim support all the way throughout to help them remain engaged in the process, to feel empowered so they can give the best evidence they possibly can at a trial to hopefully secure a conviction.
My last question is just, do you feel that the cultural change in the defence judicial system has gone far enough to improve the experience of victims?
In the last 3 years, I would say significantly, yes. having joined the armed forces in the 90s myself, and I served for 26 years, and I only left just under 4 years ago, I have seen a significant change from the 90s, thank goodness, through to when I left. And so I've been in defence for nearly 30 years. There is significant change in the cultures and the behaviours, but there is still much to do. I can't sit here and say otherwise. But the service justice system is, that's not the 100% of the picture. There is some great VORG initiatives going on in defence, the education, raising of awareness, and I think together the two need to combine to really cement that improvement.
Any other questions, Ryan?
No, just very, very quickly, it's a bit of a... Are the two, upon a conviction, Chris, are the two processes of appeal the same in the civilian and the military legal systems?
I wouldn't want to mislead you on that. I wonder if I can give you a clear answer on that perhaps tomorrow when you come and visit, when you'll have colleagues from other parts of the service justice system who can answer that far more articulately than I can.
I've asked the judge before.
Yeah.
Yes, I think Alan Large might be writing to us on that with an answer for you on that question he's just indicated. Okay, that concludes our questions this afternoon. Thank you very much for your answers and for coming along and helping us with our inquiry. We're very grateful. Thank you.
Thank you.